All right, good afternoon, everyone. Welcome. My name is Julian Moreira. I'm a program director at the Florida Department of Education, Bureau of Exceptional Student Education. Currently, I supervise a team of complaint investigators and exercise general supervision over our due process system in the Dispute Resolution and Monitoring Unit, or DRM. With me today are Ms. Joy Dunleavy, who currently serves as Program Specialist, Complaint Investigator, and Facilitated Iep Team Meeting Liaison at DRM, and Mr. Joseph LaBelle, who currently serves as Director of Programs Impact at Family Network on Disabilities. I'll let Ms. Joy Dunleavy and Mr. LaBelle introduce themselves.
As he said, my name is Joy Dunleavy, and I'm one of the investigators in the Dispute Resolution and Monitoring section of the Bureau of Exceptional Student Education at the Florida Department of Education. And I'm really excited today to share a little more with you guys about resolution options available to parents and districts.
Hey everyone, my name is Joe LaBelle. I'm the Director of Programs Impact at Family Network on Disabilities. Now, Family Network on Disabilities is the statewide parent training information center. I'm going to talk about that a little bit later. But I'm thrilled to be here in partnership with DOE in talking about alternative dispute resolution options. So I'm going to turn it back over to Julian and let's kick it off.
All right, thank you both. Just a couple of housekeeping items. This session will be recorded, and we have a lot of information to cover today, so if you have any questions, please reserve them for the end of the session. We also have cards, should you have any specific questions or concerns. Jennifer Barnhill, who is also a program specialist at the Bureau, will be passing those out toward the end. All right, so our objectives today, we hope to cover the following. We hope to help you understand and explain the Center for Appropriate Dispute Resolution in Special Education, or CADRE's, continuum of dispute resolution processes and practices. We hope to explain what mediation and state-sponsored facilitated IEP team meetings are, help you determine when it is appropriate to request either mediation or state-sponsored facilitation, and understand the process for requesting mediation and state-sponsored facilitation. So a little bit about CADRE. CADRE is funded by the U.S. Department of Education, a technical center that helps parents, educators, and state educational agency representatives implement dispute resolution systems and determine what the appropriate dispute resolution option is when resolving disputes. Supports parents, educators, and administrators when it comes to understanding mediation, facilitation, and other collaborative processes or strategies for resolving disagreements and conflict. I have a question for those of you in the audience. Please raise your hand if you've ever disagreed with your school district. Not a surprise. That's why you're here. I have a follow-up question. Please raise your hand if you've ever engaged in a conflict with your school district. So if I could have just one brave volunteer answer, what's the difference between disagreement and conflict, or what's your understanding about when a disagreement turns into conflict?
In my case, the difference was we disagreed and we tried to work it out, like communicating back and forth, sharing ideas, and trying to appreciate each other's positions. And then they lied, and so I got a lawyer. So I guess that was the conflict, was the lawyer, and then they figured out that they had lied.
All right, thank you. What was your name? Vanessa, thank you, Vanessa. So, yeah, generally disagreements are regarding one particular issue. There's a lack of agreement or consensus between the parent and the educators or IEP team members in many cases. I think one of the defining points when it comes to going from disagreement to a conflict is, like Vanessa stated, there's a lack of trust, there's a break in trust, there's a break in communication. We're arrived at an impasse, and we no longer trust the educators or the system that's meant to provide appropriate services and instruction to our students. So we've worked very extensively with CADRE to improve and evaluate our dispute resolution system in Florida. What you see here is a framework that's been developed by Cadre, which they call the Continuum of Dispute Resolution Processes and Practices. And so they've identified 5 stages of disagreement or conflict. I'm going to be talking in depth about each of these stages. Assistance or early intervention options exist as a parent or even as an advocate when you know that there's been a disagreement or conflict between a parent and their IEP team or school district. So we're going to start off at the prevention level. So perhaps the best and easiest way to prevent disagreements or to manage conflict is to prevent them in the first place. So increasing the capacity of systems and individuals to meaningfully collaborate and problem solve offers a proactive strategy for conflict management. And so if we move down to the intervention options, very first starts with family engagement. So all of you as parents and all parents in general in our state can and should participate meaningfully in their children's education, including those whose children receive special education services or who may need them. And research demonstrates that parent-family involvement significantly contributes to improved outcomes. Moving on to participant and stakeholder training. Stakeholder training is aimed at equipping stakeholders, such as parents, with skills that enhance their capacity to communicate, negotiate, or advocate for their students. A wide variety of topics may be included in the training curriculum. So for example, we are in a small workshop currently at the Family Cafe, but there are also school district level training opportunities that may exist in your school district. So moving on to stage 2, or disagreement. We're at an IEP team meeting and there may be a disagreement between the amount of services or the kinds of services or maybe even the eligibility determination. So when you've arrived at this stage, here are the following that are available to you. So we're going to talk first about the telephone intermediary, and this exists at the school district level as well as the state level. So this process involves intervening with parents and schools by telephone as soon as a request for assistance has been made. An inquiry is made by a parent and viewed as an opportunity for the office to help clarify the problem, identified informal ways of addressing the matter, and proceeding to resolve that dispute or disagreement. Many school districts, especially those that are smaller, rural, have telephone call centers that you can call in and ask for either a staffing specialist or directly to an ESC director if you are one of the smaller or rural districts. We also offer this kind of intervention option at the state level. So if you call our Department of Education and come to us with a concern, we will assign a program specialist to you to help work with you, and that back and forth can last days or even weeks until you come to a resolution that you're satisfied with. Next, we're moving on to the case manager. So case managers generally assist in remedying miscommunication and misinterpretation of the law. Finally, in this stage, there's parent-to-parent assistance. This process recognizes that you all, parents, are a valuable source of assistance to other parents, and there are many different approaches to offering a parent-to-parent assistance program. So again, many school districts do partner parents with parent liaisons to talk about just questions in general. We may not have to arrive at a disagreement or dispute, and sometimes they may even be able to come to an IEP team meeting. So we're going to move on to the more pervasive ongoing conflict stage. So clearly identified conflicts may be effectively addressed through the utilization of capable third parties. These collaborative conflict resolution options are characterized by interest-based problem solving. So again, we're at the level of disagreement or conflict where there's been a break in trust. Again, there's maybe no ongoing communication, and so a third-party intervention option may be appropriate in this stage. So we're going to begin with mediation models, and under the IDA, or Individuals with Disabilities Education Act, there is the state-sponsored mediation model and procedures. However, for this stage, we're talking about mediation models that are offered at the school district level. So a school district may contract or work with a mediator. And again, it's different than the IDA state-sponsored mediation option. This may include a panel or team of mediators where the parties come together to attempt to come to some form of signed written agreement. We also at this stage have facilitation, and at this stage we're talking both about school-level facilitation as well as state-sponsored facilitation. Facilitation, state-sponsored facilitation, is not required under the IDA, but in Florida, we choose to provide this service to our parents and teachers and educators. So again, Facilitation is a voluntary process that can be used when parties in an IEP or IFSP meeting or some other kind of meeting agree that the presence of a neutral third party could facilitate communication and problem solving. And at the state level, Ms. Dunleavy will be going in detail about our state-sponsored program. So if you've exhausted all of these options so far, you do have certain procedural safeguards afforded to you. And we're going to begin with due process hearings. So a due process complaint is a request to a school district and the Florida Department of Education for a hearing before an administrative law judge. This procedure, as a method for resolving a dispute, involves the filing of a complaint by either a parent in most cases or a school district, challenging the other party over a matter concerning the free, appropriate public education decision-making of a student with a disability. This process is the most contentious and adversarial of the required dispute resolution options under the IDA. Most due process complaints do not end up in a fully adjudicated hearing. Negotiations between the parties usually involve attorneys, usually involving attorneys, usually resolved before a formal hearing has to proceed. Nationally, this number of those due process complaints that are resolved through a withdrawal, through a resolution agreement, is 80%. And that number is much higher in Florida, which does indicate that school districts make efforts to resolve due process complaints before the need to go to a more costly due process hearing. Typically, these due process complaints are resolved through a resolution meeting or resolution session. These sessions are required under federal law as an opportunity for families and schools to resolve those issues raised in the due process complaint, but in a less formal process and setting. The resolution meeting is a prerequisite for a due process hearing and must be held within 15 days after a parent files a due process complaint. So if you file a due process complaint, you have to at least attend that resolution session, and so does the school district. If either party does not meet that 15-day requirement, the other party may move and ask the ALJ to dismiss the case. So you don't have to agree to whatever the district proposes, but you do have to attend that meeting. Next, we have the written state complaint process. So a written state complaint procedure must be available under the IDA in every state, and in Florida, we have written procedures for resolving any complaint and disseminating our procedures. So in resolving a state complaint in which we have found any findings of noncompliance, we would issue corrective action that's appropriate to resolve or remedy the noncompliance, which includes student-specific corrections, so corrections that impact your child specifically, as well as corrective actions that ensure that the noncompliance does not occur again. And again, we're going to move and talk a little bit more in depth today about state-sponsored mediation, but this is also a federally mandated procedure. And this process, again, requires that a third party, a special education mediator, sits down with the parties to negotiate, to discuss their disagreements, and come to a written settlement or mediation agreement. Oops, sorry. The final stage here, once all of these have been exhausted, is the legal review stage. So in the event that none of these process or outcomes associated with your procedural safeguards work, you may pursue these additional avenues. So there is legislation, which is a process where elected officials, through deliberation, negotiation, and compromise, write laws and grant rights, establish certain duties or obligations, and create remedies in response to emerging societal needs. Next up, we have litigation, in which families and educators have access to the court systems to enforce a right. However, these options, litigation, are only available typically once you've exhausted all of your procedural safeguards administrative processes. The last intervention option is the hearing appeal, and this only applies to two-tier systems. In Florida, we are a one-tier system. But in some other states, the school district will actually hold a hearing, and then that decision can be appealed to the state educational agency. In our case, our Division of Administrative Hearings is essentially contracted, or per statute are the actual entities that hold the hearings. And so if you have a disagreement with that decision, you can appeal that in a district court of the United States. So this graphic just shows how a parent who does come to a disagreement with their IEP team should or can approach that disagreement. So if you disagree with the school level decision, oftentimes the school district level will not be aware of that particular disagreement or potential dispute. And so again, oftentimes parents find a quicker resolution by calling their school districts, asking to speak to their ESE director or ESE compliance specialist, and asking them to look into the matter and investigate in an informal way. Again, you can also contact the Florida Department of Education, ask to speak to one of our program specialists, and we will also, go back and forth between you and the school district to attempt to get to the bottom of the disagreement and make sure that the districts are following the process. If you're not satisfied, again, with the resolution at that stage, you can also ask to or you may request a state-sponsored facilitation. We have a dedicated team that works with parents to help them understand the process, schedule the process, and maybe consider other alternatives of dispute resolution if facilitation is not the most appropriate manner in which to resolve their particular dispute. And again, if those options don't work, then you can also exercise your procedural safeguards and either file a state complaint, request state-sponsored mediation, or look into filing a due process complaint. And again, in Florida, although not federally required, we do offer facilitation and the three required federally dispute resolution options, which include mediation, state complaints, and due process hearings. I'm going to wrap up with some data, and this is the most recently publicly available dispute resolution data for our state. So in 2018-19, about 58% of complaints that went through a full investigation, meaning a complaint was assigned by the department, facts were reviewed, documentation was reviewed, and facts and conclusions were then included in the report. About 58% or 60% of those fully investigated cases led to findings of noncompliance. In contrast, when it came to our mediation numbers that same year, about 70% of mediation sessions or attempts at mediation led to a full agreement. Finally, when it comes to our due process hearing requests that same year, about 20 out of about 230 due process complaints actually went to a full hearing and was fully adjudicated. And again, this could be because of many different scenarios. For example, the parties can resolve at a resolution session or through other informal means. They may have resolved through mediation. The complaint itself may have been insufficient, and there is that component that a parent has to file a complaint that is subject to a due process hearing, that the content matter is subject to a hearing. And this is my final slide. So again, dispute resolution at a glance. Here I've presented the state-sponsored facilitation option, mediation option, state complaints, and due process hearings. And I've categorized these different, concepts or information that may be pertinent to you to help you make a decision about which one to select your school district. So the first thing we're going to focus on is time limits. And when you file a state-sponsored facilitation request, we typically schedule these within 14 to 21 calendar days, or even quicker. Get the parties to respond in a quick manner. When it comes to mediation, the same thing applies. We request the other party to give us a response about whether they're interested. We schedule them within 14 to 21 days. When it comes to state complaints, we have 60 days to fully resolve that complaint. When it comes to due process hearings, we have 75 days to resolve that complaint. And this is also subject to extensions. So either party may request an extension of that timeline, and the judge would have the authority to extend it. Same applies to state complaints. Under exceptional circumstances, we can extend that 60-day timeline, but it all depends. So again, the most expedient, most quick manner in which to potentially come to an agreement is through these state-sponsored facilitation and mediation options. I think the next important key point here is who are the decision makers. So when it comes to facilitation and mediation, parents and educators are the ones making the decisions. Although there is a third party involved, they're only there to facilitate communication. That third party is not a decision maker. You can always opt out of the process, or you can disagree with whatever the district is proposing to resolve the matter, and maybe continue through mediation or through your other procedural safeguard dispute resolution options. When it comes to the state complaint process, the Florida Department of Education would be responsible for determining or making a decision on the matter. The same applies to the due process hearing procedure, in which an administrative law judge hears both sides and they make a decision, they make a ruling. When it comes to how quick the decisions are implemented, so for example, compensatory services or an evaluation, whatever that resolution looks like, at the state-sponsored facilitation option, an IEP can be implemented as soon as that IEP is developed. When it comes to mediation, again, it's parents and educators who decide the terms of that agreement and how quickly that mediation agreement gets implemented. For state complaints, we ask our school districts to resolve the matter as soon as possible if there are findings of noncompliance, but we do have up to 1 year federally to ensure that all of our corrective actions are addressed and resolved. Same applies with due process hearing requests, so as soon as possible, but no later than 1 full calendar year. So that will end my portion of our presentation. Up next, we have Ms. Dunleavy, who will be going into detail about facilitation and mediation.
Thank you. All right, as he said, my name is Joy Dunleavy, and I'm going to go into a little more depth about the state-sponsored mediation process, as well as the state-sponsored facilitation process. First, we're going to look at mediation. So what is mediation? Mediation is a voluntary process through which parties attempt to resolve issues under Part B of IDEA and execute a legally binding written agreement reflecting that resolution. Pursuant to 30506 of the Code of Federal Regulation, mediation is in process a voluntary is voluntary on the part of both parties, is conducted by a qualified and impartial mediator who is trained in effective mediation techniques, is confidential, including discussions that happen during mediation, and is not used to deny or delay a parent's rights to a hearing on the parent's due process complaint or deny any other rights afforded under Part B of IDEA. Who pays for mediation? In Florida, exceptional student education mediation is provided at no cost to parents or districts. Mediation is paid for by the Florida Department of Education. Districts are responsible for paying for gifted education mediation, and each party is responsible for any additional individual expenses such as attorneys or advocates. A qualified mediator, an impartial individual who facilitates confidential discussions to achieve a resolution of the dispute that is mutually agreeable to both parties. Please note that IDEA mediators must currently be certified through the Florida State Courts. More information is provided at the link here. A mediator must also not be a Florida Department of Education employee or an employee of any school district or state agency that receives IDEA funds through the United States Department of Education. Who participates in a state-sponsored mediation? Parents of a student with a disability, the local educational agency or school district, other public agencies that have a responsibility for the education of students with a disability, and if the student has reached the age of majority, it would also be the student with a disability. The parents and districts may bring any additional participant to the mediation. However, all parties are required to submit to the Bureau their participants lists, which includes the name of those who will attend and their role. Because mediation is a voluntary and confidential process, the purpose of this requirement is to provide the parties with an opportunity to object to one of the individuals included in the list prior to the mediation session being held. Parents will be presenting their concerns during the mediation session and will be able to discuss any issues with their invitees privately in a breakout room or caucus, which will be provided by the mediator. Mediation topic examples. Some things that are commonly resolved in mediation are things like eligibility determination, educational placement, provision of a free and appropriate public education, reevaluation, state complaints, due processes or any unresolved issues from due process, IEP issues such as development, review, revision, and implementation. It's important to note that mediation is not an IEP meeting. In this session, no IEP will actually be developed. You can, however, as part of your resolution in mediation, qualify that there will be an IEP meeting held within a certain amount of days, and both parties can agree to that. They can even make it part of their resolution that they'll attend an SFIEP, which is going to be the next topic. The benefits of mediation. Mediation is a very effective means of dispute resolution. It's less costly. It's more expeditious in process. The relationships are improved. Creative solutions are encouraged. It is voluntarily, mutually beneficial resolution that can be reached with the help of an impartial third party. It is confidential, and it is the most collaborative. There's also a process to file for mediator grievances if you believe a mediator has violated the ethical standards for Florida, and that link is included as well. Preparing for mediation. These are just some tips for mediation. Organize the issues that you would like to discuss and come prepared. Determine your plan or proposed resolution. Be prepared to listen and demonstrate respect. Bring student records and be organized. Be flexible at mediation and have an open mind. Be patient and present, and keep the focus on finding a solution for the student most of all. Here is just a little bit of data as well for the mediation. Right now there's an 87% success rate for this year. In 2018-19, there were 42 mediations held and 29 reached an agreement. In 1920, there were 38 held and 31 reached an agreement. And so far in 2021, we've had 15 held and 13 have reached an agreement. To request mediation, there's a mediation form that you can find on our website at fldoe.org. On the bottom of that request form, there will be the mediation's address, IDEA, mediation@fldoe.org. You may also submit a request by submitting a completed form to your local school district's ESE office. Once the Bureau of Education has received the request for mediation, both parties will be contacted. As we discussed, this is a voluntary process, so we will ask for both members' willingness to participate. Digital resources will then be given out in the form of an email. A verification call will be scheduled with the parties to answer questions regarding the process. This will be held over the Zoom platform in order to familiarize yourself. At this time, mediation is being held through Zoom only. Both parties will then be asked to provide 3 dates and times that they are available, and this process is from 3 to 6 hours. Those proposed dates and times will be shared with each party until we come to an agreed upon. The mediator will then be assigned. A confirmation letter will then be sent out via email. And if the mediation is tied to a state complaint, there is an additional voluntary agreement form that both parties will have to sign. Tips for virtual mediation. Mediators are assigned based on a rotation and availability. The mediators provide their availability to the Bureau at the beginning of each month, and the Bureau confirms their availability prior to an assignment being made. So there's 3 types of agreements that can be made in mediation. One is a full agreement, in which both parties agree to all issues in dispute. One is a partial agreement, in which the parties agree to some issues, but not all in dispute. And the other one would be no agreement, when parties cannot find any resolution to the disputes they're discussing. Please note that if a parent files a state complaint and the issues are subject of a mediation agreement, they can reoccur at a later time if you choose to resolve through mediation. If tied to a state complaint and both parties have agreed to pursue mediation to resolve the allegations, and the parties would sign the voluntary agreement we just discussed, and they would also have to agree for the mediator to disclose any of those items not agreed upon at the conclusion of the mediation back to the Bureau so that they can continue to be investigated through the state complaint process. Once both parties have executed a legally binding mediation agreement, the parties are bound by that agreement, and that agreement is enforceable in court. Here is your mediation team at a glance. Again, this will be available. It's also available at fldoe.org. The next process we're going to discuss briefly is State Facilitated Individual Education Plan, or SFIEP. SFIEP is a voluntary process through which a trained impartial third-party facilitator contracted by the Florida Department of Education helps to develop or revise an individual education plan for the student. The qualifications of a state facilitator: they must possess a graduate degree from an accredited university, be able to demonstrate experience in alternate dispute resolutions to include mediation, or have extensive experience conducting IEP meetings. They must possess a knowledge of and the ability to understand the provisions of Individuals with Disability Education Act, and they must not be an employee of the school district or of the Florida Department of Education. In Florida, SFIEP meetings are facilitated at no cost to parents and districts, and facilitators involved in the SFIEP process for students with disabilities are paid for again by the Florida Department of Education. Each party is responsible for any outside parties, such as advocates or attorney fees. Who is involved in the process of SFIEP? The parents of a student with a disability, the student where appropriate, the local educational agency or school district, the IEP team members that meet the requirements of 321, and any person that the parent indicates has knowledge of the student and is invited by the parent. Dissimilarly to mediation, for SFIEP, someone cannot object to a member. Because there is a legal obligation part of the school district to have certain members present at an IEP team meeting, you are not able to object. As well, there is a protection for the parent to invite anyone they feel has knowledge of the student, so the district can also not object to any member. So this process is a little different than mediation in that way. Commonly resolved issues using SFIEP: the increase or decrease in services, accommodations, change of placements, reviewing and revising IEP goals, and evaluations. Benefits: again, revised IEP for the student. This is at no cost to either party. It's an accelerated process. Relationships are preserved. This is a much more collaborative option. Neutral facilitators may help the IEP team members overcome barriers. SFIEP can help restore broken or damaged relationships and reestablish the trust between the district and the parents. How do you know when an SFIEP is appropriate? So here are just a few scenarios. If an IEP team is spending more time trying to resolve conflict than working on coming up with a plan for the student to be successful. If the IEP team meets multiple times with little or no resolution in sight. If the parent wants help overcoming a particular obstacle that is preventing the progress in the development of the IEP, or there is a history of contentious interactions between the parent and the school staff. Here is a little bit of data from SFIEP for 1920 and 2021. Out of the 41 SFIEPs held in 1920, 36 came out with a revised IEP. In 2021, 49 were held, and 42 came out with a revised IEP. And again, keeping in mind that this time frame is that 14 to 21 days. So this is a much more expedient process than state complaints or some of the more contentious options. 86% overall success rate. The process for scheduling SFIEP is very similar to mediation in that the SFIEP request form is available at fldoe.org. On the bottom, it will indicate the web address and the email address those can be sent to, sfiep@fldoe.org. The scheduling process begins when the Bureau receives the request. Again, this is a voluntary process. Once both parties have agreed, the Bureau will notify all participants that there is an agreement. The district will then is required to provide some dates and times. The facilitators, the liaisons for facilitation, will go back and forth between the Bureau and the parent until they have reached a mutually agreed upon date and time to have the SFIEP. After that time, the Bureau then assigns a facilitator to conduct the meeting, and the confirmation letter is sent to the district, the parent, and the assigned facilitator via email unless otherwise indicated. Here are some additional resources about facilitation and your SFIEP team at a glance. And Mr. Joseph LaBelle is now going to come.
Thank you so much. Give me 1 second. All right, so I'm going to jump back and go back to one of Julian's previous slides for this activity. Where is that continuum? Perfect. All right, so first and foremost, my name is Joe LaBelle. It's good to talk to all of you. Like I said previously, I'm the Director of Programs Impact at Family Network on Disabilities. Family Network on Disabilities is your statewide parent training information center. So we are funded by OSEP up at the Federal Department of Education to provide information, training, resources, and support to all of the folks in this room, both district staff, parents. Everything we do is free of cost. When we work with families, we really hover in those first kind of 3 stages right there. We work with family engagement, presentations. We help field questions from families when there's dispute or conflict. And then once it gets into that due process and procedural safeguards area, we're going to help explain what options you have and then make sure that you guys are connecting to the right either department inside Bs or making sure you're connecting into other services that can really take it from that point. Everything we're doing for families is information driven and free of cost. So again, you know, it's Family Network and Disabilities. Make sure you check out our information. So I'm going to jump into this. So the activity that we have, I'm going to go through a couple scenarios that we wrote out. And I want to see by a show of hands where on this continuum that you think the scenario may fall. And then what type of dispute resolution option might be the most appropriate for that scenario. So the district was not able to evaluate a child in a reasonable timeline. Once the evaluation was completed, the student was found eligible. The district has offered compensatory services, and there is a disagreement about the amount of services. So where do you think that really falls inside of the stages? So a show of hands, how many people think that falls in stage 1? Not really. How many people think it falls inside of stage 2, disagreement? Yeah. How many people think it falls inside of stage 3? Okay. And then how many people think it falls inside of stage 4? Okay. And then stage 5. That's kind of extreme. So really we're looking at it could fall inside of stage 2 or 3. There's kind of potential for either one of them. But we're talking about a simple disagreement of the amount of services. So in this one, we really want to focus on taking that initial step of mediation to have that open conversation. So again, preserving relationships. This is the school is saying, yes, I want to offer these services. There's just a disagreement about the amount of time and services that's going to be offered. So let's start with a mediation session to really open up that communication, see if we can have an agreement that comes out of that, a resolution. Second scenario. A principal, in this case, the LEA, is at an IEP meeting and is not providing parents with a clear understanding of what options they have if parents disagree with the IEP team's decision, okay? So a principal is at the LEA is at an IEP meeting. The parent disagrees with the IEP team's decision on whatever's happening. And the parent feels as if that the LEA is not providing, the principal is not providing clear understanding of what options they have to move forward, okay? So where do we think this could fall? Inside of 1? No. Inside of 2? Okay. Inside of 3? Okay. Inside of 4? Okay. And then inside of 5, probably not. So really, this is a conflict. It's a a disagreement or a conflict. Again, it could go inside of 2 or 3. At this point, we really want to focus on the fact that it's that individual principal or the individual staff member that the parent is having a disagreement with, a conflict with. So what do? At this point, we talk about that scaffolding and the kind of the ladder of chain of command. We want to go from that local school-based environment and then reach out, so local resolution, reach out to the school district, reach out to the IEP or the ESE director inside that school district, and see about opening up that conversation. Family Network on Disabilities, we work statewide, Pensacola down to the Florida Keys. And I can tell you, 99% of the cases that we work with, I mean, no one calls us when they're happy. That's just a reality. But 99% of the cases that we work with, it's a couple different things. It's miscommunication. It's folks that are really trying on both sides. They're trying so hard to get the right outcomes, the best outcomes for students. A lot of times they're saying the same thing, or they just need a little bit of help and support from the district staff. So when we get the district involved, that's really when tensions come down and when we're able to move past issues and focus on that child again. So at that point, we would look more at local resolution. Next one, the parent feels like the IEP is rushing through the meeting, that the IEP team is rushing through the meeting and not allowing them to give input and asking to sign quickly before fully understanding what is being done for their child in the newly drafted IEP, okay? So parent feels like we're rushing through, asking to be signed very quickly. You know, that happens from time to time, and we can feel that. So where are we inside of this? Are we inside of stage 1? No. Stage 2, disagreement? Nope. Stage 3, conflict? Yeah. Stage 4, the procedural safeguards, okay? And then stage 5, probably not, I don't have any stage 5 in here. So really, what I'm kind of thinking about and focusing on this one, you're feeling rushed. You're feeling as if you haven't had the opportunity to really express what you want to talk about. This is a great opportunity for a facilitated IEP. Inside of a facilitated IEP, you're going to be able to take a moment. You're going to be able to have some opportunities to express what you would like. It's typically a longer duration of time that they're putting aside. So really finding ourselves inside that stage 3 and utilizing that state facilitated IEP is a wonderful option. You know, we talk about state facilitated IEP and mediation, and then of course there's state complaints. We tend to want to go from 1 to 100, which there are all these other things in between. It's really, really important when we talk about preserving the relationships because it's a long road and we want to focus on who? Our student. So the last one that I have is the district is offering parent training to help families understand IEPs better. The training is being done and being offered by Fiddlers, which Fiddlers is great. If you guys don't know Fiddlers, go check out their website. They're wonderful. It's being offered by Fiddlers, FND, and district staff. So where do we find ourselves inside of the continuum? Stage 1? It's stage 1. So that's another thing that I really want to focus on as well. When we're talking about these different activities, when we're talking about these different scenarios, a lot of what we do at FND is geared at that prevention, okay? And the districts across the state, wherever you're living, they're offering these trainings. They're offering opportunities. A lot of times, they're offering them through our partners. So through Project 10, through Fiddlers, through Finn, through these discretionary projects. We're really lucky in Florida to have so many discretionary projects funded by the Department of Ed. There's a lot of states that don't have those opportunities. So making sure that we're going on the ESC website, we're looking at their calendar, we're reaching out to staff and finding out what educational opportunities are available so that we can be of assistance to the district and making sure that the district is being able to be assistance to us, right? So thank you so much for allowing me to do this activity, for allowing me to chat with y'all. I'm going to turn it back to Julian for a few moments, and then we're going to wrap up for today.
All right. Thank you so much, Joe. So that wraps up today's presentation. I believe we have maybe five minutes to maybe take a couple of questions that any of you may have about today's presentation. If you have specific concerns regarding specific students, again, Jennifer Barnhill has question cards for you. We're going to take these back to the Department of Education and go through them and assign specialists to respond to each of those questions. So again, does anybody have any questions that we can today? Saw a hand there and then a hand here. That's a really good question. I think I can elaborate on how the process works now. So we maintain a list of facilitators. We go through a rotation, so we make sure that we keep the impartiality there. So we have, I think, like what do we call that? Like a docket, just a list of facilitators. A lot of our school districts receive facilitated IEP team training. So they train their staff to do facilitations at the local level. So it may be that you contacted your school district and requested one through that process. I'm not familiar with us assigning a facilitator who works for the school district. I'm not sure that's been our practice, but state-sponsored facilitation would be its own process. The facilitator would not work for the school district. They aren't employed by us. They will be paid by us, but again, they're a neutral third party. Mm-hmm.
I called the state, I asked for a state facility IEP. Maybe my district in turn's response was they didn't necessarily agree with wanting to have a state facility IEP. So instead, so they can just tell you guys, no, the parent can't have this?
Right. We always encourage our school districts to hold the FIEP team meetings, but it is voluntary. It's also voluntary on the part of the parent. Again, there are no specific procedures under federal law. It's actually not even codified in our state rules. So we maintain that it's a voluntary process. But again, I think our agreement rates to participate are relatively high. And every time that we do get a request, we'll consult with the district and say, hey, especially if they disagree, what's going on? Why did you say no? So we do have a debrief with our school districts. Sure. Yeah, and we're happy to follow up. So I highly encourage you to fill out the card. I'm going to stay here after for about 15 minutes so we can talk if you'd like. Yes?
You have stage 4, but you can't do stage 4 unless you have filed for a due process hearing, had the hearing, and or you filed for a due process, denied a hearing, or that the fact of doing the due process hearing is so pointless and impossible to do, you can then go file up in federal district court, as I case against Manatee. For scenarios, you have to go through stage 4 to be able to do 5.
Right, thank you. Yeah, that's absolutely a great distinction. You do have to exhaust those administrative processes, including due process, to go to litigation, to go to your district U.S. Court of Appeals. So, are we good? Do you have a specific question, or are we good? Okay, thank you. Appreciate it. Anybody else? All right. Well, thank you so much.